issued a notice to appear. They could be given an adult civil citation, or they could fall into this other bucket, which is non-arrest cases. And what we have found is that there is an abundance of non-arrest cases that are being forwarded to the office, and the time of our prosecutors is having to be spent in sifting through these cases, which delays justice for the community. So there are thousands of cases of non-arrest that are pending. So that you're clear, there are nearly 45,000 active cases within the 9th Judicial Circuit currently at this moment. 30,000 of them are cases that have come through either arrest process, the adult civil citation process, or the notice to appear process. However, the remainder of those cases have come through the non-arrest process. There are approximately 13,500 non-arrest cases that are currently pending. And what happens, because the arrest cases receive priority, those other cases sit on the back burner. And sometimes it takes up to 2 years to have those cases effectively prosecuted. Now, I want to tell you that this isn't something new. This isn't something that just happened. I was looking at an article today that was written back in 2013 that was talking about the backlog of cases in the state attorney's office. And it referred to non-arrest cases as the culprit of that backlog. And that was when Jeff Ashton took over the office in 2013. Since that time, the problem still exists. It existed under my first administration, and under my first administration, we were combating that problem by hiring more people to sift through these cases. So there were a number of individuals that I hired specifically for the purpose of processing non-arrest cases. Well, in the interim, and I think everyone here is aware that I was away from the office for a period of time, and during that time, the individuals that I hired for that purpose were either let go or reassigned to other duties. And the gains that we had made in reducing those non-arrest numbers during that time allowed those numbers to climb back up again. And like I said, at this point, we have 13,000 non-arrest cases that are in our office. What this does is it delays justice for our victims. It delays justice for the community, and it's an unnecessary cog in the wheel of justice. So in order to address this situation, I am at this time, and as of April 1st, we are no longer accepting non-arrest cases in most circumstances. We are asking and enthusiastically looking forward to collaborating with our law enforcement partners to build the best cases possible so that when that case comes into our office, we can get right to prosecuting it and delivering justice for the community. So at this time, I'm just going to ask Dave to come and give you, from a law enforcement perspective, the different options that are available to law enforcement when they're called for some crime that's been committed, and then how that case ends up in our office. Dave?
Good afternoon again. My name is Dave Allman. I'm one of the investigators here at the State Attorney's Office. You may ask what an investigator at the State Attorney's Office does. Well, we have 13 sworn law enforcement investigators. We're sworn police officers, and what our role is once a case gets to the State Attorney's Office, we assist the prosecutors in preparing the case for prosecution and through all the tasks for prosecution. But our investigators have a wealth of experience in law enforcement, so my goal in the next few minutes is just to give you a general idea of our collaboration with law enforcement and how we partner with our partners in the community who wear the badge to ensure that justice is served. So typically, you may understand that someone calls 911 and the police, law enforcement, go to their house because there's an allegation that a crime has been committed. So the police go and they conduct an investigation. And now the police have what's called probable cause. They need to develop this probable cause, which is a pretty low standard, in order for them to take action. And the way that the police officers do it, when they arrive on a scene, they conduct their investigation. That's the best time to conduct an investigation because the people are there, the physical evidence is there, everything they need. So if a police officer on the scene develops probable cause to determine that a crime has been committed, they have several options at that time. They actually have the option to make a physical arrest. If the person that committed the crime is there, they can take their handcuffs out and arrest them, take them to jail, and in that situation, the court process starts within days. That investigation is sent to our office, and we assume prosecution. That person is removed from the streets until we can determine if prosecution is warranted. So they have that option if they develop probable cause. They also have the option, let's say they go to a criminal scene and they determine this person committed a crime and that person is gone. Well, they can go to the courthouse, they can get an arrest warrant from a judge, and then every law enforcement officer in our jurisdiction will be looking for them to take them into custody and arrest them. And once that person is arrested, they're taken to jail. That investigation within days comes to our office, and we can initiate that prosecution and see that justice is served quickly on that person. They also have a number of other options. If it's a nonviolent offense, they can file a notice to appear, which is basically a piece of paper that says, hey, you need to show up for court and you need to answer to this. Now, the cases that we're talking about, the majority of them this morning are what we call non-arrest cases. That's where a police officer goes to a scene or conducts an investigation, and they may or may not determine probable cause. We have cases where they have determined probable cause has been made, and what they do is they don't use the option to make a physical arrest or get an arrest warrant. They simply send that case to our office, and that's the backlog of cases that we're talking about. So it delays justice a little bit, and we have to evaluate the cases. As Madam State Attorney said, we have hundreds upon hundreds of those cases just sitting here awaiting for us to take action. So that's a little bit about the system. Just know that in the community law enforcement, we collaborate with them. Once they do a case, they send it to us, and then we work together. They're law enforcement, we have law enforcement and prosecutors. So our goal here today is to eliminate that backlog, because we don't think that the citizens deserve to, have cases that are just sitting around because we may lack the resources. We focus on cases that we've actually gotten, that someone has actually been arrested, and then all kinds of speedy trial issues come. So the lion's share of what we focus on are those cases. So that's just a little very general idea about how someone gets to our office.
Thank you, Dave. And I want to just kind of emphasize what Dave said, is that when someone is arrested or they are otherwise brought into the court system by either a notice to appear or an adult civil citation, that makes sure that they are under some sort of supervision at that point. Because if they're arrested and they get out on bond, there are going to be pretrial release conditions that someone is constantly monitoring them. What I'm concerned about is that in the stack of 13,000 non-arrest cases, there might be a dangerous person. And if that person is not being monitored, if their case is not going through the system, then they could commit another violent act, and that is a danger to our community. So this is a proactive policy in an attempt to make sure that that doesn't happen, so that we make sure that we are utilizing the full resources of law enforcement and the state attorney's office to do everything that we can to keep our community safe. So I'm really looking forward to collaborating with law enforcement and their legal advisors to make sure that every case that comes through this office has probable cause, and that we can go forward in doing everything that we can to keep the community safe. So at this time, I will take some questions, and as Dave said, I'd like them to remain on topic so that we can use the best of the time that we have here.
Absolutely. Just talking about, these cases that will be addressed, with arrest warrant without. Just so I understand, your agency is asking local law enforcement to push harder to make sure they're obtaining these warrants, correct?
Well, I think that that's only partly true. I think that because there are a myriad of different things that law enforcement can do to present us a case, getting a warrant is not the only thing that they can do. They can also give the person a notice to appear, so that that case automatically gets into the process of the court system. They can give an adult civil citation. But in the event that they can't locate the individual and an arrest is warranted, then yes, we're asking that they get an arrest warrant.
And that whole backlog of, tens of thousands of, cases that you guys are getting into your office, did the majority of them creep back up when this office was under leadership of Attorney Bain?
Well, What I know is that under my leadership, I hired individuals specifically focused on processing that backlog of non-arrest cases that I found when I took office in 2021, and that was inherited by my predecessor, and as the article that I read this morning from 2013 said, that was even inherited by the person who was in office before her, right, Mr. Ashton. Those individuals, after I left office, were either released or they were reassigned. So during that time, there was not any significant processing of non-arrest cases that were happening. So yes, under their leadership, those non-arrest cases did creep back up.
Does today's announcement have anything to do with the Florida Supreme Court's opinion that was released today that would aim to keep dangerous criminals off the streets or stopping them from being able to get bond before the first appearance?
It doesn't, because non-arrest cases mean that someone doesn't even have an opportunity to get to the place where they would get bond. So it's completely separate and different, and this is something that, again, I was attacking in my first administration. I came back and immediately took stock on the things that are not running efficiently in the office, and the managers in my office immediately indicated that this was one of those things that we needed to address right away. That's not on topic for this particular issue today, but I look forward to discussing that at a later time. Mm-hmm.
Does your office plan to make an announcement or something somehow addressing that opinion that was announced today from the Supreme Court?
I mean, we'll review it, and if there's a reason for us to respond, then we will do that, but it's not unusual for the Supreme Court to make opinions that impact our day-to-day work, and when they do, we adjust our practices to ensure that we are compliant with the law.
Attorney Worrell, I mean, everyone had all eyes, just talking about the previous, election back in November, all eyes was here on the, state attorney's office of District 9, because there was so much that happened. And so, moving forward, would you say that this initiative, if you will, this new plan moving forward, is how you plan to, be tough on crime? Because that's, what your constituents voted you into for. They re-elected you. They wanted you back representing this district. Is this all part of that to try to prevent more crime here in Central Florida?
Well, thank you for acknowledging the fact that, yes, I am back at a mandate. The constituents of the 9th Judicial Circuit re-elected me overwhelmingly because they believed in the work that we were doing in our first administration. I've never wanted to just be tough on crime. We also have to be smart on crime. And I consider this another smart justice initiative where we can acknowledge the inefficiencies in our system, and we take steps forward to ensure that we address those inefficiencies so that we can deliver swift justice, not only for the victims, but also for the offenders, for our community as a whole.
Can you speak to the mutual combatant cases on the list there? Because we know, obviously, domestic violence is an issue that you're also prioritizing.
Yes.
Could you explain with that particular reason being left off this list of cases?
Right. So that's one of those cases where if law enforcement can't make a probable cause determination as to who is the aggressor of that incident, if there isn't probable cause, we'll never be able to get it to beyond a reasonable doubt. And one of the things that I've always talked about is the different burdens of the different agencies. Law enforcement's burden is probable cause. We then have to take probable cause and take it to reasonable doubt. So if you think of it in the context of a football game, right? One pass takes it to a certain amount of yardage, and somebody has to take it into the end zone. Law enforcement starts it off, and they're taking it up the field, but ultimately we've got to score the touchdown. And if they can't get probable cause, then we'll never be able to get beyond a reasonable doubt. So if a case comes in and it's a mutually combatant case, as you mentioned, and we can't determine who the aggressor is, and there weren't any injuries so that we can identify who's at fault for this incident, then that's not a case that we're ever going to be able to prove beyond a reasonable doubt.
And as for gun cases, that referring to possession type charges, or which type charges are those gun cases?
So gun violence is a huge priority of my administration. It always has been. And I am completely and wholly uncomfortable with someone who is charged with any type of firearm offense being left at large while we try to determine if there's probable cause or reasonable doubt. In those cases specifically, we're requesting that an individual either be arrested or that a warrant be obtained for their arrest.
Would that answer also go similarly for
Yeah, absolutely. If it's a violent case, that person should be in custody. And then a judge can make a determination as to what happens next, whether or not they should be released on bond with pretrial release conditions, or whether or not they're such a danger to the community that they need to remain in custody.
Is this policy meant to be something that a law enforcement officer becomes aware of and then becomes more likely to make an arrest on a case?
So that's definitely not the intention of this policy. Again, I am very enthusiastic about the potential for us to work collectively with our law enforcement agencies and their legal advisors to make sure that we're building better cases, we're building stronger cases, and that when cases come here, they have the requisite probable cause that we can then take and turn to reasonable doubt, beyond a reasonable doubt.
How are just staffing levels overall since you've resumed your position as state attorney? Are you tend to bring back some of the folks who are like those that
So there have been many individuals who've reached out and expressed their interest in coming back. Some of those people absolutely have come back. Something that's important to understand, and I'll talk more about this in the coming days, is that government work everywhere is going to feel that pinch of being understaffed, right? We have people who have enormous caseloads, and the salary is not the greatest. So people who do this work, the men and women who you see standing behind me today, as well as those throughout the building, they're here because they believe in this work. They love serving our community, and they want to make whatever sacrifices are necessary so that they can continue to do that. So we are ongoing in recruitment. Our staffing levels are about what they were in my previous administration, and we'll continue to recruit and fill spaces as they become open.
What does this mean? So out of those 13,000, over 13,000 non-arrest cases, what does this mean about those that are currently on this list that you guys not be accepting that are a part of those caseload right now? Are you guys still going to address those?
Yes. Yes, that's right. So we are going to make our due diligence, and we're going to process the cases that are currently within our position. The attorneys that we have are doing both arrest cases as well as non-arrest cases. So they are going to continue to process the cases that they have within their possession, but this is a going forward. Here's a more efficient way that we can work on this and bring justice to the citizens of the 9th Judicial Circuit. So no more will prosecutors be sitting in their office going through stacks and stacks and stacks of unending files of non-arrest cases, and no longer will victims have to wait to see how long it's going to take for their case to get through. And no longer will we lose sight of offenders because so much time has passed since the offense was committed and the time that they're actually brought to justice. And no longer will the very real threat of danger exist that someone who's already committed offense is still at large and they'll be able to commit another offense while they were waiting on us to get to their case a year or up to 2 years later. All right. Thank you all so much for being here. I look forward to speaking with you again soon.